Here now, attorney Mercedes Colwin. Mercedes, this was a case about self-defense and a right to protect yourself, pure and simple. Your initial reaction to this verdict?
I have to tell you, Dagan, I was really surprised, and I'll tell you why. There was a ruling last week, the whole provocation jury instruction that was given to that jury, which in its sense said that Rittenhouse, by the mere fact that he went to the protest with a gun, provoked the attacks. I really thought that was such a game changer. But the game changer for the defense, and I have to tell you as a defense attorney, it is one of the hardest decisions you'll ever make when defending a client, is whether or not to put that client on the stand. Putting it on the stand was essential. And frankly, during the deliberation, when I thought to myself, my God, 30 hours, and any defense attorney, nearly 30 hours, any defense attorney will tell you that the longer it takes for a jury to come back with their decision, the more you start to think that there may be a conviction. It was pretty amazing that during the readbacks, what they were looking for, they were looking at videotapes. So they had blown past the provocation jury instruction that the prosecution had set forth last week and for the judge to rule upon, and then obviously said it during closing. And really, we were just focusing in on exactly what you're saying, on this self-defense. That's why they were looking at the videotape. They went past this whole argument that the mere fact that he brought a gun provoked the attacks.
Mark Richards, one of his defense attorneys, actually said this, and let me bring in Bob Bianchi, criminal defense attorney, former New Jersey head prosecutor. He said, in Wisconsin, if you don't put a client on the stand, you're going to lose. And he also said about the jury, they didn't have a lot of questions. There was no word of any fighting in the jury room. So this was a defense attorney along with the co-counsel, Corey Rafisi. They were very confident in this, Bob, but also weigh in on the defense or the prosecution here, because the prosecution was just a disaster in myriad ways.
Well, as a former homicide prosecutor, let me start with that. They made a charging decision within days of the incident, before the autopsies were done, before all the crime scene evidence was collected, before all the witness statements were done, before all the videotapes were reviewed. I've conducted these investigations, led these investigations, and tried these investigations on much less complex facts than this. And we take our time to go slow and steady, right? So they didn't do that here. And the defense was able to use that in the closing argument to say this was a rush to judgment in order to calm people down because of what was going on in Kenosha at the time. And my experience informs me that, in fact, is accurate. Number two, the prosecutors did a number of things in the case, which regrettably, as a former prosecutor, I'm saddened about. Most importantly, in my mind, commenting on the defendant's right to remain silent on the witness stand, what we call post-arrest silence. That was an act of desperation. Number three, 4 of the witnesses that the state called to the stand gave testimony that actually assisted the defense to the self-defense, including the third victim, Ghost Cruz, who indicated that he was being attacked at Rittenhouse, he was being yelled at, he was trying to get away, and each of those witnesses indicated that they felt that his life was in danger. Now, the prosecutor wanted to go in summation and say the mere bringing of the gun, which, by the way, the gun charge got thrown out, was provocation. But that is not the law. The law that was read to the jury was provocation is when you're engaging in unlawful conduct of a type likely to provoke others to attack. That's what they had to find. And what this jury came out and said was he wasn't the one that was attacking them. They were the ones that were attacking him. If anything, the state's own witnesses indicated that when Rittenhouse moved the weapon and somebody backed away, he put the weapon back down. When the threat was removed, he put the weapon down. When Ghost Cruz came after him, he didn't shoot him when his hands were up until he took his weapon and pointed it towards his head. I told you before, this is a no-brainer of a self-defense case. And the only thing that concerns me is that this became a case about narratives as opposed to facts. And that is the reason why our country is in the shape it's in, especially the judicial system. We operate on law and facts, not narratives. And I've been there. I've been there when the media is reporting on stuff that's happening in the courtroom at trial. And I've gone to reporters and saying, how could you possibly have written what you've written or done what you've done? And I've literally been told, well, it didn't fit the narrative my editors wanted.
To paraphrase something I saw on Twitter of all places, that if you're surprised by this verdict, then you're getting your news from the wrong source. But I want to get, before we go, I want to get you both your reaction to this. And there's been, in terms of the incendiary false commentary, well, the false narratives continue. But this is from sitting New York Attorney General Tish James. The Attorney General of New York tweeted this: "This is a dark day for our justice system. As a lawyer, I respect jury verdicts, but this is yet another reminder that our system needs to be uprooted and reformed." Mercedes, what is she talking about? Getting rid of innocence before guilt? Getting rid of jury trials? This is the Attorney General, the top law enforcement officer in the state. What is she doing?
Look, I do have great respect for AG James. I obviously, with respect to Governor Cuomo, I thought she did an outstanding job. I'm going to set that aside, my own personal beliefs. But Bob and I are both trial lawyers. We have tremendous respect for juries, tremendous respect for the trial process, tremendous respect for judges. We were not the one of 12 individuals sitting there who deliberated the fate of Rittenhouse. We did not hear the testimony. We did not see the evidence. We did not look at the videotape. Maybe we saw it as in a two-dimensional setting like we are today, but we were not there. So unless you're one of those 12 that sat through 2 weeks of that jury trial and 26 hours of deliberation, and by the way, 26 hours of deliberation, back and forth, talking, readbacks, looking at the jury instructions, listening to the jury instructions. Those are the individuals that can opine about what took place. All of us ourselves included, need to sit back and say, believe in the process. The process works.
But
I've been practicing for 31 years. And Bob, I think you're about the same age as I am. We are seasoned trial attorneys. We do believe in the system. And when you have that type of testimony and statement and tweets, it's something that shouldn't occur.
I want to get to, but I want to read this, what also the former governor of New York, Andy Cuomo, had to say. And you want to talk about liberal politicians recklessly, irresponsibly trying to fuel rage and distrust in this verdict. Here's what Andy Cuomo had to say as he gasped for relevancy. "Today's verdict is a stain on the soul of America and sends a dangerous message about who and what values our justice system was designed to protect. We must stand unified in rejecting supremacist vigilantism and with one voice say, this is not who we are." This vomitous ghoul keeps regurgitating this false narrative about a young man who today was acquitted. Bob, final word.
It's sad. And what saddens me most about it is that I'm pretty confident these people making these comments didn't even watch a wick of this trial. Whereas Mercedes, people like me and Mercedes, watched every second of this trial. Liberal lawyers, conservative lawyers, defense attorneys, prosecutors, all knew that this was going to be a difficult case for the prosecution. We all knew. That's why the prosecutor asked for lesser included offenses, because he saw his case going down in flames. And the fact of the matter is, I ask this question: is this the criminal justice system we want, when the lower socioeconomic defendants who are on trial every day, day in and day out, is this what we want? Prosecutors commenting on their right to remain silent, having narratives, calling them things, facts that don't support the evidence. Do we want this in our criminal? Hey, it's not about Kyle Rittenhouse. It's about our Constitution.
Right. Or having a MSNBC freelancer following the jury bus who just happened to get caught. But what if he hadn't gotten caught? Mercedes and Bob, it's great to see both of you today. Thank you so much for being here and bringing your expertise, as always.